Generally, federal antitrust laws, including the Sherman Act, are intended to increase consumer welfare by preventing or suppressing monopolies and unreasonable restraints on trade or commerce that lessen competition. But what about policy decisions made by state governments or governmental actors that lessen competition? Are these actions subject to federal antitrust laws? In Parker v. Brown, the United States Supreme Court addressed this question. In 1933, California enacted the California Agricultural Prorate Act to prevent agricultural waste during the Great Depression. The California Act established programs for the marketing of agricultural commodities produced in the state, which restricted competition among growers and maintained a minimum price level. The California Act also created the Agricultural Prorate Advisory Commission, whose job was to select and oversee program committees that created proration marketing programs for commodities produced in specified zones. And although the system included participation by local farmers in the form of public hearings and voting, final authority for administration of the programs was with the Advisory Commission. In 1940, a program committee that was established for Zone 1 created a seasonal marketing program for raisins. At the time, Zone 1 produced almost all the raisins consumed in the United States and nearly one-half of the world's crop. Under the program, raisin producers had to deliver all the raisins they wished to market to a specified receiving station. At the receiving station, the raisins were classified as either standard, substandard, or inferior. 20% of the total standard and substandard raisins were required to be placed in a surplus pool. In addition, 50% of the entire crop was required to be placed in a stabilization pool. The committee would then pay the producers a certain price for their deliveries into the surplus and stabilization pool, depending on the variety of raisins. Subsequently, Porter Brown, a raisin producer and packer in Zone 1, sued W.B. Parker, the State Director of Agriculture, members of the Advisory Committee, and members of the Program Committee in federal district court under the Sherman Act. Specifically, Brown sought to enjoin enforcement of the program, arguing that it prevented him from marketing his raisin crops, fulfilling sales contracts, and purchasing and selling raisins in interstate commerce. In response, Parker filed a cross-complaint seeking to enjoin Brown from refusing to comply with the program. He argued that the program was a valid exercise of California's police powers. Following trial, the court found in favor of Brown, concluding that the marketing program illegally interfered with interstate commerce. Parker appealed to the United States Supreme Court.